It's somewhat conventional to try to explain the genesis of papers. This one, I think, is explained as follows. Many years ago, too many years ago, I dabbled a little bit in this originalism debate, staking out a position I described as Burkean interpretation and juxtaposing it to original interpretation. And then I sort of dropped that for many years and went off and worked on things like property theory and administrative law and so forth. And recently I've been intrigued with the thought of trying to get back into the game a little bit. So this paper is sort of a preliminary attempt to re-engage. Now, the paper I'm presenting here is not an anti-originalist paper. It's not a paper like some of my earlier writing that sort of suggests there's a kind of a mutual exclusivity between originalism and what I used to call Burkean constitutionalism. The idea here more is that the originalist arguments tend to have their own little domain, which is somewhat separate from other types of arguments that are made. So just to give you some examples, if in fact Congress and the people had succeeded in amending the Constitution to permit flag burning to be proscribed by law, it seems to me that a court interpreting that amendment would almost certainly have and done so, at least in their initial confrontations with it, in an originalist fashion. They would have tried to understand what the purpose, if you will, or the instructions from the people were in adopting that amendment. They would not have done, as at least one law review article suggested, said that, well, the amendment only allows Congress to pass laws to prescribe flag burning. It doesn't mean that the courts have to sustain convictions for flag burning. That would have been inconsistent with what I would call faithful agent, or what you would all call as originalist interpretation. In contrast, if an issue comes up in the court about whether certain types of disabilities imposed on women rather than men are permissible under the Constitution, the argument will almost certainly take place in terms of interpreting various precedents that the Supreme Court has adopted going back to the 1970s, dealing with gender discrimination. The argument will not take place in terms of whether or not the 14th Amendment did or did not include discrimination against women as part of the proscriptions of Section 1 of the 14th Amendment. It will be argued strictly in terms of settled precedent. So I'm not against original interpretation. I think that there's a certain sphere in which obviously it would dominate, and properly so. But my contention is that there's a wider menu of decisional norms than simply those that can be derived from originalism. So where I'm headed is very close to where Jack Balkin ends up, but the path is very different, and I think the normative assumptions are different as well. A couple of advantages. So my paper argues that the discussion might be helped by refocusing from legitimate interpretation to legitimate adjudication, and a couple of points about why I think that might be advantageous. One is that I think it tracks better with actual practice. Talking about original adjudication is going to produce a larger menu of decisional norms than talking about interpretation in the abstract. I think that the originalism debate has a kind of unreality problem. Much of the discussion is conducted at a very high level of abstraction and doesn't really get down too much to the actual level of application to real-world decisional controversies. I think Larry Solom's work is sort of an extreme version of this, where he talks endlessly about how in the abstract to interpret texts, but then disclaims ever offering an opinion on how an actual case ought to be decided. Secondly, I think that focusing on original legitimate adjudication promises to produce a more constrained conception of the judicial enterprise than does focusing simply on originalism, whether it be new originalism, old originalism, or what have you. And in this sense, I think my normative priors are very different from Jack's in that I am very much in favor of a constrained judiciary, and that's because I'm a small d Democrat. I very much would like to see public policy made as much as possible in a kind of interactive fashion between the people and their elected representatives and interpreters, as opposed to being made in a kind of isolated chamber in which elite lawyers argue to elite judges and make policy in that particular form. So what's the theory? The theory, I'll have to try to summarize it very quickly, starts with the observation that adjudication is always about dispute resolution. So, and I think this is true definitionally. Sometimes adjudication performs other functions, as I concede, but it always comes back in some form or another to dispute resolution. The problem faced by every adjudicator is that there's going to be a winner and a loser in almost every case, and so how does the adjudicator convince the loser to accept the result as something other than being ganged up on by the adjudicator and the winner? The capacity of adjudicators to enforce their judgments is limited. They have to rely on the executive branch for enforcement, and the system would break down unless, in most cases, the adjudication results in an outcome that the loser, although disagreeing with the outcome, nevertheless acquiesces in and regards it as legitimate. I talk about there's a number of institutional features of adjudication that contribute to legitimacy, including things like reason giving and focusing on facts and being independent and not being corrupt and so forth, and I don't have time to summarize all that here. The thing I do focus on, because it overlaps with the discussion about originalism and interpretation, is the decisional norms that the adjudicator relies upon. These norms have to be perceived by the parties as having some kind of objective quality that's independent of the preferences of the adjudicator. The primary one, of course, these days is law, pre-existing law, but historically you could have other things like throwing people in vats of water and seeing whether they sink or rise to the top. That would be objective because it would be independent of the desires of the adjudicator as well, but we have our own social practices which focus on law. The dominant criterion of legitimacy, from this perspective, I argue, is expectations, the expectations of the parties as advised by their lawyers as what type of decisional norms are going to be applied. In this sense, the lawyers working on behalf of the parties and making arguments to the court or the adjudicator, as well as explaining to their clients whether the outcome is consistent with expected norms or not. It's kind of an interpretive community, if you will, or some kind of coordination device that produces this sense of legitimacy. All this is kind of a descriptive as opposed to a normative sense of the situation. So what are the legitimate norms of adjudication in America today? I argue that there are five. Some talk here about Philip Bobbitt, my colleague, who has six, and Richard Fallon, who has five. Jack has 11. I don't really think it matters exactly how many there are. I think you can slice and dice this in different ways. But my five include some sort of subcategories and so forth, so I don't think that's the issue. The question is which norms have a broad basis of consensus in our society. So I argue that there are three basic norms that have a broad consensus in the sense that these norms, these categories of norms, are accepted as legitimate without regard to their specific content. One is faithful agent arguments, originalist, if you will, arguments, which I think are very much accepted as legitimate. Certainly in the context of a recent enactment, a statutory case, for example, these arguments dominate and are regarded by everyone as appropriate. Secondly, is precedent. We live in a legal system that derives from the common law, and so arguments from precedent have been bequeathed to us by that system. Those are regarded as legitimate. My third category is settled practice. I actually think this is much more important than most people realize. The Supreme Court frequently invokes settled practice in resolving constitutional cases, as in the Noel Canning case, for example, involving the recess appointments clause, would be a recent example of this. My contention is that the so-called super precedents are actually in situations of settled practice, that we're not going to override the administrative state, or we're not going to declare that paper currency is unconstitutional And that's not because of the precedential force of the decisions that authorize these things, but because they become embedded in settled practice. Two norms I think are qualified. One is our moral arguments. I think you can use moral arguments as a basis for adjudication in a legitimate way if there's a very strong consensus about the moral argument. Dworkin's Elmer's case, where the guy tries to murder his grandfather to get an inheritance, that everyone would agree that murdering somebody to get an inheritance is a bad thing to do. That's a highly consensual norm. Contested moral norms, I think, are more problematic, probably by themselves would not sustain a sense of legitimacy. And social welfare arguments, I say, are similar. Strong consensus may be good enough, but otherwise it's going to be sort of frosting on the cake.